This Mr. Walston guy needs to be criminally prosecuted, needs to lose his license, and I hope he and his secretary spend some time behind bars. I really mean that. We need to, basically, this should not be tolerated today in our society. You know, the police are under, basically are being reviewed very critically, especially by the Black population, because they've been victimized for such a long time. And the tide is turning now. And laws are being passed now. And I think it's important that people be treated respectfully. I don't care what color you are. And you shouldn't be victimized. And so I think today in our society, I think the same goes here. If you have a rogue attorney, an errant attorney who acts in such a despicable manner, that person needs to be punished. And a slap on the wrist doesn't do justice. But putting someone like that behind bars, that's going to send a strong message in our society. We are not going to tolerate that type of misconduct. Zero tolerance. You're an attorney at law. You need to act professionally. Integrity and trustworthiness is of extreme importance here. And if you deviate from that, we're coming after you. In January 2016, I hired Mr. Walston because he professed expertise in civil rights. He told me he worked for the Department of Justice and he knew everything about civil rights. So I was very impressed with his credentials. He handled the federal lawsuit fairly well. It did get thrown out because the defendants had immunity, and immunity is a real problem today. It's extremely difficult to sue police because they have immunity. And they can exercise discretion, and a lot of leeway is given to the police. However, that may change in the future. In 2018, he handled a state lawsuit, and it got thrown out because of immunity. And I was very disturbed because he was very excited about the amended complaint that he prepared, and he thought I had a real strong case, and it got tossed out completely. And I was shocked. I was really shocked. So I started doing some legal research, and I discovered that Mr. Walston did not know that there was a loophole to get around the immunity issue, and it's called exercising discretion. And the amazing thing is, and this completely befuddles me. I don't understand why the so-called experts that do civil rights, they don't understand that there are some loopholes to get around it. And going back into 1968, the California Supreme Court had a very famous landmark decision called the Johnson decision. And they basically said that if you're a police officer and you just make a discretionary decision, you might not necessarily have immunity. You might not be protected. What you have to do is called exercising discretion. And there's a distinction. Exercising discretion means basically weighing the risks and the benefits of your decision. And if you don't exercise discretion, guess what? You don't have immunity. It was an incredible legal principle. And I brought that to the attention of Mr. Walston, and he didn't know anything about it. And I was shocked. They said, well, you've been practicing for 21 years, and you're telling me you're the expert. And yet I'm teaching you something that's been around since 1968 that you never even heard of. It's mind-boggling. I should write a book about it. That's almost unheard of. And I talked to other lawyers who profess expertise in civil rights, and they never heard about exercising discretion. So I basically had to rescue my case because I knew my attorney was, well, basically incompetent. And so I had to basically draft the future complaints in the lawsuit. And I think I did a pretty good job. The problem was that when we were approaching trial, I had to reach out to my expert witness. And I don't want to disclose his name because he doesn't want to get embroiled in this. He's a highly renowned expert witness, and he was the only one available in my case. And when I called him to let him know that there was an upcoming trial, he didn't even know who I was. He didn't even know Mr. Walston. I said, I don't understand. I gave Mr. Walston $5,000 in December of 2016 to retain you. And he said, I never got the money. And I said, I don't believe that. How can Mr. Walston screw up so badly? So I contacted Mr. Walston. I said, Mr. Walston, we have a serious problem. Our expert doesn't have the $5,000 I gave you, and there's no contract. We've got a major problem here. Let's go to work and resolve the problem. And I thought that he was going to take care of it. I went into my billing statements, and it turned out that he misappropriated that money. The $5,000 was earmarked to go to the expert witness. And instead, he paid down my general account. And you can't do that. You can't do that. That's why they're called trust accounts. And so if you give an attorney money that goes to an expert, which is a third party, that money has to go to the expert. You cannot start moving that around to different places. It's misappropriation, which is actually embezzlement. And since it's over $900 in California, it's actually a felony. It's actually a crime. Well, the trial was continued from October 2019 to October of 2020. And obviously we had the pandemic in 2020, and I had a deposition with the California Department of Justice on September 17th, 2020. It was a videotaped deposition. It was done remotely because of the pandemic. And when I was asked the name of the expert witness, Mr. Walston told me not to tell them. That's totally inappropriate. All attorneys have told me that the three most important rules in a deposition is 1, tell the truth, 2, tell the truth, 3, tell the truth, because you're sworn under penalty of perjury. And so what Mr. Walston did, I believe, illegally interfered with my deposition testimony, telling me not to tell the Department of Justice the name of my expert witness. And that's improper. When you're telling a client to lie, that's called subornation of perjury, and that's also a felony. Very disturbing. And I didn't understand why he didn't want me to disclose that. You would think, what's the big deal? Telling the name of your expert. In fact, my deposition was September the 17th, 2020, and my experts was calendared for September 30th, 2020. So the following week, I contacted Mr. Walston. I said, Mr. Walston, I want to be at our expert's deposition. I want to take notes. This is very important. And he told me I can't reach our expert. I said, what do you mean you can't reach the expert? I said, this doesn't make sense. And he also discussed about possibly getting another expert, and I didn't understand where this was leading. So I got on the phone, and very easily I contacted my expert, Ann. And I said, sir, your deposition's coming up in a week and a half, and I'm giving you a heads up. And Mr. Walston told me to, just prepare you for this. And he got very upset, and he said, again, I don't know Mr. Walston. I don't know who he is. I never got any money from him for a retainer, never got a contract. And I'm saying, what the hell is going on here? And then my expert asked, did Mr. Walston tell the court that I am the expert witness of record? And I said, yes, sir. And he exploded with anger. He was so mad. He basically said, this is the second time this has happened in my 38-year career. And I'm calling my attorney, and we're probably going to file a state bar complaint against Mr. Walston. So I tried to reach Mr. Walston. I called his office, his cell phone, left email messages, voicemail messages. He's a difficult person to reach. His communication skills are really abysmal. They're atrocious. He doesn't really know how to communicate with other people very well. I've learned. Later that day, at the end of the day, about 6:30 in the evening, he calls and he says, what happened? Did our expert die? And the reason he asked that was because our expert's about 80 years old. So I guess that's a legitimate question. I said, no. And I said, you better call him. We have an emergency situation here. He's very upset. Here's his number. You give him a call. Now, at this point, I was really incensed because the year before, I gave him a heads up. I said, we've got a potentially serious problem. Our expert never got the $5,000 I paid you to retain him, and there's no contract. You would think that most attorneys would say, hey, this is a serious matter. We better get this resolved. And he didn't bother resolving the situation. And legally, that's called mitigating damages. If something happens, you want to mitigate damages. So now we have a situation where Mr. Walston has embezzled $5,000, a felony. He suborned my perjury, that's a felony, and he failed to mitigate damages. Now, back in 1988, the Supreme Court of California had a similar situation, and guess what happened to the attorney? The attorney got disbarred. Okay, so now, also I want to mention that the expert suggested, in a very friendly way, you probably should get yourself a new attorney. And I thought that was really good advice. I said, yeah, I think the way things are going, it's time to look for a new attorney. So I began looking for a new attorney, and that took a couple of months. And while I was looking for a new attorney, one person suggested, why don't you call your expert again? This was around October the 23rd of 2020. And just to find out if Mr. Walston ever, if he ever contacted the expert just to see what's going on. And so I called him again. I said, we had that discussion the month earlier. By the way, did Mr. Walston ever follow up? Did he ever call you to square things away? And he said, no, I've never been retained. I really didn't hear from him. Nothing's happened. And I was just infuriated. I was just basically saying, what is wrong with this man? Are there mental issues here? What is the problem? Is this guy an idiot? I mean it sincerely. I said, I don't run into people like this. And so finally in December, I get a letter from Mr. Walston. And he said, what is my status? What is my status with you? Am I still your attorney? I know you've been looking for another attorney to possibly replace me. There was an attorney called Scott Brewster. He contacted the California Department of Justice, and he was kind of confused. He didn't know what his status was. And so I basically sent him an email. He says, don't worry, I've got a new attorney now. And his name is Mr. Swanson, and he'll be contacting you shortly. This was in December of 2020. And while the underlying case, the civil rights case, is now being handled by Mr. Swanson, this new attorney, I contacted an older attorney that I've known for about 20 years. And I said, I think it's time to maybe sue Mr. Walston for malpractice, for legal malpractice. And he agreed. His name is Mr. Frank, and he's in Sacramento. And he agreed. He said, you know what, I think that you've been damaged. He cost you 2 years because he screwed up the complaint and you had to redo it. And so you lost 2 years and you paid him. And there was some negligence there. And so I think you've got a bona fide legal malpractice case. So at the end of January of this year, 2021, Mr. Frank sent a pre-suit demand letter to Mr. Walston saying, I represent Steve Turner in a legal malpractice case against you. We haven't filed suit. This is just a demand letter. And we were seeking $205,000 for damages. And you would think that most attorneys would hand that over to your malpractice insurance. I know Mr. Walston has malpractice insurance because in California, if you don't, you have to disclose that to your client. You have to let your client know, I don't carry malpractice insurance. And so you have to understand that if you want to retain me. And so he didn't mention that. So the default situation is he's got legal malpractice. And we were certain he was going to turn it over to his malpractice carrier. Instead, shockingly, on February 8th of this year, he sent a counter demand letter to Mr. Frank. And he said, no, Steve Turner actually owes me $50,000. And the reason being is that on September 17th of 2020, during his deposition, he was acting sexually inappropriately to my secretary. And I'm reading that, and I said, what the hell is this? This is a blackmail letter. This is like a woman falsely accusing a man of rape. And I'm saying, this is horrendous. What is going on here? I was shocked. And so I contacted the state bar because I filed just shortly before this letter, I filed a complaint also with the state bar while we were suing or attempting to sue Mr. Walston for a malpractice. Mr. Frank said, yeah, you better file a complaint with the California State Bar because this man has broken some serious rules and has violated the law. So I contacted the investigator at the state bar and I said, you won't believe this. I hope you're sitting down. But I just got a blackmail letter from Mr. Walston and with a preposterous charge that I was acting sexually inappropriately in front of his secretary on the day of my deposition in his office. And so the investigator said, you better send that letter to us. So I sent the letter to the investigator at the state bar. And so we call that the blackmail letter because it definitely is blackmail. And I said, isn't it interesting that he alleges that I did this act, sexually inappropriate act, on September the 17th? But guess what? He forgot about the December 4th letter he sent to me. Because the December 4th letter is the smoking gun letter. It doesn't say anything about anything happening on September the 17th that was sexually inappropriate. And he also said in that February 8th letter that I told you about, that blackmail letter, he said, oh, by the way, after my secretary told me that you were doing that sexually inappropriate thing to her, at the end of the deposition on September the 17th, I told you clearly you need to find a new lawyer. So you look at the December 4th letter, why would he say, what is my representation? Am I still representing you? It's so obvious. It's so obvious the guy's lying. And there's nothing about September the 17th. You would think that if an attorney says, I'm no longer your attorney because of what you did to my secretary, most attorneys would file a motion to withdraw with the court, immediately getting off the case. Like 2.5 months later, and with a letter saying, am I still your attorney? What's going on there? So people that have looked at the evidence, it is very, very clear that that's a blackmail letter, that there was a malicious lie involved in doing this. It's preposterous that an attorney who's also an officer of our courts, he's an officer, he's a legal officer of our state and federal courts. This is just reprehensible, and it's deeply disturbing. And I think this man needs to be criminally prosecuted. And I like to see him behind bars because he's a dangerous person to do this, to pull off a stunt like this. And I also told the investigators, without any hesitation, I'll gladly submit to a polygraph examination because I'm 100% honest. And what Mr. Walston has done is beyond the pale. It's really, people are shocked. I also notified the FBI and the U.S. Attorney General, and I'll tell you why, because now Mr. Walston is facing wire fraud because he sent the letter, the extortion letter, based on a phony, false charge using the internet. And that's wire fraud. That's a felony, a federal felony now. So now we can add attempted extortion because I didn't pay the $50,000. I'm not going to. And he used the internet to transmit a blackmail letter, so now he's facing a total of 5 felonies. And you got to wonder what's going on with this man. I think he's got mental issues. This is not normal behavior. Again, The appropriate thing to do, if you're an attorney at law and you get a pre-suit demand letter, is you turn it over to your insurance carrier. And if you've done nothing wrong, you relax. You let the insurance company handle it. So I think at the end of the day, this man's going to lose his license and he's going to be criminally prosecuted. The state bar told me if they get clear and convincing evidence that a crime was committed, they refer the matter to the state bar, to the district attorney. So the San Francisco district attorney may very likely file criminal charges against this man, and the secretary is in trouble. And I'm looking to sue both the secretary and Mr. Walston. Because there's a conspiracy here to extort money from me based on a malicious lie. And this is just outrageous, and I think the world needs to know. And I hope someone cracks down. And at one time, the California State Bar was very lenient, but hopefully there'll be no leniency here, and they should throw the book at the guy and set an example. This is outrageous because we hold lawyers to a higher standard. And since they're an officer of our courts, and integrity and trustworthiness, these are important principles for lawyers to have. And for this man to act in such a reprehensible manner it's got to be deeply disturbing when people hear the story. And it's 100% true. And interestingly, you don't see too many reviews on the internet that are signed off. I declare under penalty of perjury the foregoing is true and correct. You don't see that, but my reviews have that. Every one of my reviews, I end with that last sentence. I declare under penalty of perjury that the foregoing is true and correct. And so what I'm telling you is 100% correct. And that's pretty much the story. And it's pretty... as I said, it's deeply disturbing and it's very shocking. I was shocked when I saw that February 8th letter that they would concoct such a malicious lie, such an underhanded lie.